Hi. So thank you very much for coming out today. We are on the cusp of the start of another Supreme Court term, and this one promises to be as exciting as the one we just finished. So the Supreme Court always begins hearing cases on the first Monday in October, so that will be this coming Monday. Um, in addition to specific cases that we'll obviously be watching, there are some other things we're going to be wanting to kind of keep an eye on. One is whether we see any change in the way the court operates, the way it communicates with the public, et cetera, in light of the opinion leak last spring of the Dobbs opinion, a leak which seems to have been ultimately legitimate. It was basically the opinion that was released in June. This is also, of course, our first chance to see Justice Jackson kind of in action on the Supreme Court. And it will be interesting. You can sometimes tell during oral arguments how the justices are getting along by how they interact with each other during oral arguments. And then you also get a sense of the justice's personality. For example, Justice Thomas for many years asked very few questions. He has now started asking more, but that's a relatively new phenomenon. So it'll be interesting to see Justice Jackson's style. And then I think the other thing we really want to keep an eye on is just Chief Justice Roberts. He has kind of a really strong opinion about the importance of precedent. And we've seen this in many of his decisions over the years, but we know that there will be opportunities in the next term or two or three to potentially really change the legal landscape and make it into something that he might actually agree with more. And it will be interesting to see whether he kind of sticks to his guns regarding stare decisis, or whether instead he kind of takes advantage of the shift in the court's membership and starts to support overturning precedent a little. So what I wanted to start with were a couple of cases that on their face do not seem terribly exciting, but I think they're super cool. They happen to be the first two cases that the Supreme Court is hearing this term, both on Monday, and both of them turn on the definition of language, which I just think is so cool. The Sackett case has been going on forever. This is a very old case that has gone up and down and back and forth. But at its heart, the Sacketts own a piece of property in, I believe, Idaho, and they wanted to build a house on it. I think actually now they have built a house on it. And the issue pertains to some wetlands that are on this very large piece of property. The Clean Water Act gives the Environmental Protection Agency the power to regulate waters of the United States, which they actually refer to as WOTUS, which cracks me up. And so the issue here is whether these wetlands on the Sacketts property are waters of the United States within the meaning of the Clean Water Act. The Sacketts argue that waters of the United States should not include wetlands unless those wetlands are directly connected to a navigable waterway. And in this case, they're not. There's no like lake or river or anything around the wetlands that they connect to. So it's going to be interesting to see what the court says. Ultimately, we don't care that much about what happens on the Sacketts property, but this is going to have some pretty massive impact on the ability of the EPA to regulate wetlands more generally. The other case, and again, I just think this is fun, is a case called Delaware versus Pennsylvania and Wisconsin. This is a case that is being brought under the Supreme Court's original jurisdiction because it is a suit between states as states. And it relates to the business, which I'm sure you've probably heard of, called MoneyGram. The MoneyGram is a company. They issue regular money orders, right, which we'll talk about in just a second, but they also issue what they refer to as official checks. And these are checks that MoneyGram is responsible for paying, right? They're responsible for the funds, but they are issued on behalf of people who don't have bank accounts. So there is a federal statute that relates to abandoned property. What happens if I write a check to my landlord, for example? So the bank knows that the check is out there, but for some reason, no one claims it, right? It actually wouldn't be a check that I wrote, but a check that the bank issued, right? What's called a third-party check. And those third-party checks, the bank knows that they've been issued. So they will sort of quarantine your funds so that you don't have an overdraft. But if no one ever cashes the check, the money is no longer yours because you had this third-party bank check issued. Similarly, with money orders and traveler's checks, if those items are not cashed ever, they become abandoned property. And there is a federal statute that says that money orders, traveler's checks, and other similar written instruments other than third-party bank checks, that those documents, money orders and traveler's checks, if they are abandoned, the money goes to the state in which they were issued. So if I go down to the corner grocery and I get a money order and then it's never cashed, that money then becomes the property of the state of Texas because the money order was issued in this state. If a third-party bank check is unclaimed, a third-party bank check, the money goes to the state that serves as effectively the residence for the bank that issued it. So in this case, MoneyGram is a Delaware corporation. So the state of Delaware, what happened was MoneyGram had this massive internal audit to figure out how many outstanding checks and money orders needed to be turned over to states, right? Funds that needed to go to the states. And Delaware said that all of these official checks were theirs. And we're not talking chump change. Pennsylvania alone alleges that more than $10 million should come back to Pennsylvania instead of going to Delaware. So the question is whether these official checks that MoneyGram issues are more like money orders and traveler's checks, or are they more like third-party bank checks? They are like money orders in the sense that the money is taken from the payor at the time the instrument is created, and the payor compensates the issuer with a fee, and they are not technically issued by MoneyGram. So if you want one of these official checks, you actually have to go to a bank to get it. But it's not the bank that's going to pay the money, it's MoneyGram that's going to pay the money. They are more like third-party checks in the sense that they're issued by financial institutions. You can get a money order by going to a gas station, but you can't get one of these third-party checks. And they are made payable to a specific individual, which again, money orders are not. And money orders and traveler's checks, if you lose them, you can get them replaced. So they can be voided and you could get a new one. With these official checks for MoneyGram, you can't. So this seems like a ridiculous issue, whether this one particular instrument created by one particular company is a money order or a check. But there are millions and millions of dollars at stake, particularly for Delaware, which may owe a lot of states millions and millions of dollars. Good times. We also have 2 federalism cases on the very near horizon. Gotta love a good federalism case. One of them actually originates out of Texas. It's called Halland versus Brackeen, and the Supreme Court's going to hear it on November 9th. It's actually one of a group of cases that have all been consolidated. Halland is the Secretary of the Interior, and Brackeen is, and the rest of the petitioners are people who are trying to either foster or adopt children who are recognized as being members of Native American tribes. Oh, there's a raised hand. Jocelyn, yes.
Hi, can you hear me?
Yes.
Isn't our current Secretary of the Interior Native American?
Maybe.
I just found the case, like a level of irony to the case, I guess.
Yeah, well, I mean, the particular statute at issue is old. And the tribes actually really support it. The Navajo Nation and the Cherokee Nation are also parties in this kind of octopus of litigation, and they are on the same side as the Secretary of the Interior.
Okay.
Yeah.
Okay. Interesting.
So the Indian Child Welfare Act was passed in 1978, and it was passed actually because there was sort of a history of really bad actors in the Bureau of Indian Affairs. And there was this tendency, the BIA would actually kind of pay states to take Native American children off of reservations and place them with white families. There was a lot of sort of abuse of the child welfare system on tribal lands. So the Indian Child Welfare Act was meant to protect the interests of the tribes in maintaining their cultural identity. So one of the things that it does is that it creates a fairly high bar for removing Indian children from their natural parents, from their biological parents. It's much easier to remove the kid who lives on Hickory from his parents, right? The other thing it does, and this is actually possibly much more problematic, is that it creates a very strong preference for placing children who are deemed Indian children with either members of the child's extended family or with members of the tribe. And that being a member of the tribe here really means being a registered member of the tribe, not just being culturally affiliated with the tribe. And when I'm talking about extended family, this could be extended family in another state, right? So very far away. There's no sort of geographical consideration in these placements. So Brackeen's case is actually really interesting. I looked up exactly what happened to the Brackeens. They had fostered a child who was removed from his mother when he was 10 months old. And the mom was Navajo, his dad was Cherokee, and mom seemed to be totally okay with it. So was dad, actually. The child lived with the Brackeens for about a year. Both of his biological parents supported the Brackeens adopting him, which is what they wanted to do. But the Navajo Nation and the Cherokee Nation both stepped in, and they kind of had a little, conference about whether this kid was more Navajo or Cherokee, and decided he was Navajo, and said that as a result, he should be placed with a Navajo foster family that was not even in Texas, right? That was in another state, because this was available. As it turned out, that family eventually withdrew from consideration. They said, oh, we take it back. We don't actually want a kid. And so the Brackens were able to adopt this little boy, but he has a half sister and they want to adopt her also. And the tribe is fighting that tooth and nail. They do not want this family to adopt this little girl, even though it would mean she could live with her brother. They want to place the girl either with a great aunt or with another foster family, all of whom, again, live in a different state, live several hundred miles away. So there are sort of two issues here. The Brackens and the rest of the foster families or potential foster families, potential adoptive families, they argued that, first of all, this is racially discriminatory, not with respect to them, right? They're not claiming we are being discriminated against because we are not Indian. They're claiming that actually the children are being discriminated against because they are Indian, that if the children were not Native American, the entire process would be guided by what is in their best interests. But instead, according to the Brackens and the rest of the petitioners, these kids are being treated like a tribal resource, as being more like property of the tribe, and the tribe's interests are being included in the calculation in a way that is not fair to the kids. The other issue is the federalism issue. And the claim is that Congress has the power to regulate commerce with the Indian tribes, but that digging into the child welfare system, which is traditionally the realm of state courts, is unconstitutional. That child welfare, whether it's on tribal land or not, should be a state issue. This is going to be really interesting. Keep an eye on Neil Gorsuch. Neil Gorsuch has this really interesting, almost preoccupation with Indian law. So I'm sure he has an opinion about this, and I'm kind of dying to see what it is. I will lay odds that he will write either the majority opinion or the dissent, depending on which side he's on. This is something he really cares a lot about. So yeah, it'll be interesting to see. There's there's another federalism case. If you've taken Political Science 4200, either in the past or if you're taking it now, you're probably familiar with the Commerce Clause, right? This idea that the federal government gets to regulate interstate commerce. There's a doctrine associated with the Commerce Clause called the Dormant Commerce Clause. And it's sort of like the inverse of the Commerce Clause. If the federal government can regulate interstate commerce, that suggests that state governments cannot, right? So that's what this case is about. In 2018, the voters of California overwhelmingly adopted something called Proposition 12, the Farm Animal Confinement Initiative. And what it did was set like minimum square footage for animals, for veal calves, for breeding pigs, and for laying hens. So the idea is that like the pigs have to be able to turn around, stand up, lay down, and I forget what the other thing is, but they need some square footage because they're big animals. They need space. And Prop 12 also says that you cannot sell meat or eggs that are produced in violation of Prop 12 within the state of California. So there are basically no pork producers in California. It's not a pig state. It's not a pork state. But 13% of the US pork market is in California. They consume 13% of the pork in the US, which is a lot, right? So pork producers, pork farmers, I guess. Do you farm pork? Whatever. They
Yeah, you farm it.
Pig farmer, yeah. So the pig farmers need to be able to sell in California because it is a huge market. But according to the national pork producers, these square footage requirements are not feasible at all. There's no way to run a profitable pork operation if you give pigs this much space. And so the effect is that pork producers across the country are going to need to abide by the California rules, even though they're not in California, so that they can sell their pork in California. And that the effect of this is going to be to knock some of them out of business and dramatically raise the cost of pork. So the national pork producers are claiming that California cannot take an action like this when it has such a massive economic impact in other states. We very rarely get animal welfare cases going to the Supreme Court, so that in and of itself is interesting, but it's also a really interesting dormant commerce clause issue, particularly because California is often doing things like this, right? Like the emissions on cars, for example. A lot of companies now simply cater to the California requirements so that they don't have to figure out which cars can and cannot be sold in California. California often has much more stringent regulations of various consumer products than the rest of the country does. So this could have really big implications for California, but also a whole host of other non-pork related industries. I will pause quickly for questions before we move on. Anybody? I'm talking real fast.
I guess I was thinking, so what does that mean sort of for, like, say industries like legal marijuana in California? Like, doesn't that mean that other states are functionally limiting their ability to export those products too?
That's a good question. So I think for marijuana, it's not so much that other states are limiting California's ability to export marijuana. It's that the federal government is doing that, because marijuana is still illegal at the federal level. So if you're growing marijuana in California, you're probably not going to get prosecuted, because the state does not care, right? Because you're doing something that is legal according to the state. What you're doing is still technically a federal crime, though. It's just that the federal government has generally decided they're not going to enforce those laws in states that have legalized cannabis. But that's why, like, cannabis growers can't use federally insured banks. So it ends up being largely a cash business, or like a PayPal based,
Which results in them like making the outside of the buildings really, really like discreet.
Yes.
I was in Los Angeles recently and we visited a dispensary, and on the outside it said mattress factory, and we drove right past it at least once.
Oh, that's funny.
We were like, where is this?
Now in Oregon, all of the dispensaries have like neon green crosses in front of them, like the Red Cross symbol. So you can spot a dispensary a mile away, but they are often fairly discreet. Like they tend not to advertise much, right? And yeah, the dispensaries that I've been to in Michigan are also, you can spot them, but other than like that one symbol, it's not real clear what's happening. And there's a lot of security in these places, because again, it's a largely cash business. So I'm not sure if that answers your question, but I think the problem California faces with exporting pot is with the federal government, not with the states that haven't legalized. They can't export to Colorado either, and it's legal in Colorado. Did that answer your question?
Yeah, that makes sense.
Okay, cool. Anybody else? Okay. So we're going to have an affirmative action case. It's going to be argued on Halloween. Very exciting. It's actually two cases. One is Students for Fair Admissions versus University of North Carolina. And the other one is Students for Fair Admissions against Harvard. Normally, these two cases would have been consolidated, and there would just simply be one oral argument, but they are being kept separate so that Justice Jackson can participate. She was on the Board of Overseers, which is like the Board of Regents for Harvard for about 6 years. So she has to recuse herself from the Harvard case, but this is going to allow her to hear the UNC case. Now, what's interesting is that the two cases are otherwise almost exactly the same, except that, of course, UNC is a state entity, and so it has like this additional constitutional dimension. But otherwise, the cases are the same. And it will be weird if Justice Jackson's participation ends up affecting the who wins, right? So if it's like a close decision either way, we could end up with the Harvard decision being one thing and the UNC decision being something else, which is just bizarre. So for those of you, again, who have taken civil rights and civil liberties, you probably remember the Grutter versus Bollinger case of 2003, which was an affirmative action case based related to the University of Michigan. And the Supreme Court said in that case that trying to achieve a diverse academic environment is a compelling government interest that can justify racially conscious admissions policies. Those policies have to be narrowly tailored, right? You can't use race in a really clunky way, but as long as these are the least restrictive means you can take, you can have race conscious admissions policies with the goal of diversifying your academic environment. Make sense? So Grutter was also a weird decision in terms of participation. It ended up being 4-3. So only 7 of the justices were actually able to participate because Justice Kagan had been involved with the case as a member of the Solicitor General's office. So she had to recuse herself. And Justice Scalia died before they issued the decision. So he ended up not being on the opinion either. So what we were left with was this kind of odd arrangement of people, with Kennedy, Sotomayor, Breyer, and Ginsburg supporting the University of Michigan, and Alito, Thomas, and Roberts not. Right? But now, right, Kennedy, Breyer, and Ginsburg are gone. Kagan will come back into the mix and will presumably be in favor of affirmative action programs. I don't want to speak on her behalf, but my guess is that's the case. Alito, Thomas, and Roberts are, of course, still around. Scalia, obviously, still dead. But then you have Kavanaugh, Gorsuch, Barrett, and Jackson. Jackson won't be able to participate in the Harvard case, but she will be able to participate in the UNC case. And so the question is, will Alito, first of all, will Roberts stick with his position that he's opposed to affirmative action, or will he want to continue to support Grutter because of his preference for precedent and stare decisis? So we don't know what he's going to do. And then the question is, Kavanaugh, Gorsuch, and Barrett, what are they going to do? My guess is that they're all going to be opposed to affirmative action, and they are not going to consider racial diversity to be an adequately compelling government interest. But I don't know that, right? We really don't know. Any questions about affirmative action? Again, this would be huge, right? Because the vast majority of institutions of higher ed use some form of affirmative action, whether that is race-based or gender-based or both, in order to create more diverse classes. So depending on the outcome of this case, it could have pretty major effects across the country.
How common is it for justices to do what you're saying Roberts might do, right? To sort of say, I disagree with that judgment, but I don't think that we should change precedent that quickly.
It's not super common. The person that I know who has done it the most is Roberts. He has done that with abortion cases, right? You know, he's not a fan of Roe versus Wade. And in the cases from a couple of years ago, you know, in one case, he was in the dissent. And then in the next case, he was in the majority because he said, we've already decided this issue. I'm not changing, right? I still don't agree with it. I still don't like the policy, but we've already decided this issue. And then even in Dobbs, he said that he felt that the Mississippi statute was constitutional, but he did not want to overturn Roe and Casey because he doesn't like to overturn stuff. He's pretty dogged. Now, I don't know whether his position in those cases would have been different if his decision had been the deciding vote, right? The fact that there's a larger conservative group on the court kind of gives him the freedom to, he's still gonna win. Does that make sense? Like, he's still gonna get the policy he wants. He just doesn't have to do it. He can let the others kind of take care of the policy while he gets to stand up for precedent. So I don't know whether, you know, he is truly principled or whether he's principled as long as he can still get the policy he wants. I just don't know. It's going to be really interesting to see. Yeah, probably. I mean, the chances are pretty good that they're going to strike down affirmative action just based on like who's involved, even if it's just Alito, Thomas, Gorsuch, Kavanaugh, and Barrett. But it's still going to be interesting to see if what Roberts does. Dr. Martinez-Ebers, did you have your hand up? Did you wanted to chime in?
Here we go. Sorry, trying to unmute, trying to turn on my camera. Can't seem to do either one of them. Can you hear me? Can you hear me, Wendy?
Yes, we can hear you.
Okay, I don't know why. I don't know why my camera's not working. Anyway, I wanted to ask what kind of effect these decisions would have on laws like we have in Texas. Like, it's not top 10% anymore. I think they just go with the 8%. But wouldn't that put some pressure on legislatures either to keep the law, because in Texas they want it to go away, or would it also be perceived as you can't do these things anymore either, because the purpose of the top 8% was to create diversity on campuses, even though they didn't use race admissions? I mean, it had the same intent in terms of the question. Does that make sense?
No, it makes perfect sense. And actually, the in between Grutter and Gratz and now, the one major affirmative action case the court has heard was Fisher versus University of Texas. And Abby Fisher's argument was she's white and she'd applied to University of Texas and she was in like the top 12% of her class.
Right.
But she wasn't in the top 10%. So she was competing for that like 19% of University of Texas students who aren't in the top 10% of their class. And she was rejected. And she claimed again that I don't know whether she challenged the top 10% rule or whether she just challenged the fact that she didn't get in otherwise, right? That she didn't get in the regular admissions process, but she lost. So yeah, I mean, this is clearly, yes, it's definitely gonna bring back sort of scrutiny of the top 10% rule, because that top 10% rule, the effect is to make the remaining seats so fiercely competitive. And so I do tend to think, it's a separate question whether they can have this kind of roundabout policy that does diversify, but that doesn't explicitly mention race.
Because the goal is, again, diversification. And if the courts decide that's not a compelling interest of the government to ensure diversity, it seems like all those, and we're not the only state. There are other states who've gone the way we have in terms of diversification. It means all of these things are going to go away.
It really could. Yes, absolutely. I don't know that it will, but it would certainly make all of those policies super vulnerable. Yeah, that's a very good point. Yeah, because Texas doesn't really have, our state institutions don't have sort of explicit affirmative action, but we do have diversification policies. So yeah, it's going to be a big deal, one way or the other. It's going to be a very big deal.
Right.
Thanks, Val. Any last questions about affirmative action? Okay, the independent state legislature theory. So I highly recommend Googling independent state legislature theory, because what you will find is that there's a lot of stuff out there about it, and it almost all talks about how this is a fringe theory, except it 100% is not a fringe theory anymore. So this position, this sort of mindset, is based on Article 1, Section 4, which gives the regulation of federal legislative elections to the state legislatures, which is not in and of itself super controversial. But this theory argues that because the Constitution textually commits regulation of elections to state legislatures, those legislatures should not be crossed, I guess, should not be thwarted by anyone, including other state entities like the courts. Right. So it has huge implications if it were adopted. And it has, until like the last 10 years, truly been a very fringe theory. In Bush versus Gore in 2000, that ultimately didn't turn on this issue. But in his opinion, Rehnquist, his concurring opinion, they were all concurring opinions, right? There's no real majority in Bush v. Gore. But his particular opinion talked about the independent state legislature theory, and his position that the state of Florida, their courts, had no business changing any deadlines, because the US Constitution gives that power specifically to the state legislature. It came up again. Now that was with Scalia and Thomas. Rehnquist and Scalia are gone, but Thomas is still here. And in 2020, as you recall, we had tons of lawsuits about various issues relating to the election. One of those issues involved the Pennsylvania Supreme Court issuing an order telling the Pennsylvania election officials that they had to take and count all mail-in ballots that were received within 3 days of the election. And there was a petition to the Supreme Court by Pennsylvania Republicans. The court didn't even review it, right? They just said, no, we're not going to hear this. We're not getting into this. You're on your own. But Justice Alito, joined by Thomas and Gorsuch, issued an additional order, right, or an additional opinion saying, we actually think the Pennsylvania Supreme Court ruling was unconstitutional because of this independent state legislature theory. The state courts should not be dictating the terms of federal elections. So the Moore case is another one out of North Carolina. North Carolina is giving us lots to think about this year. North Carolina's state constitution actually forbids partisan gerrymandering. That's not a violation of the federal constitution at all. Racial gerrymandering is, but partisan gerrymandering is fine as far as the federal courts are concerned. But North Carolina specifically does not allow for it. And North Carolina law has this weird provision where if a map gets rejected, it can be given, the task of creating the map can actually be given to the state courts. So in last November of 2021, the North Carolina legislature created a new district map. And the population of North Carolina is roughly 50% Democrat, 50% Republican, roughly, right? It's always a little dicey, but thereabouts. And based on sort of forecasts of this new map, 10 of the 14 seats that North Carolina has in the US House would be Republican, right? So this was a pretty blatant partisan gerrymander. And so the North Carolina courts vacated the map, and the North Carolina Republican Party once again, like immediately went to the Supreme Court in February of 2022 and said, please, 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 you have to reinstate our map because we're coming up on primary season, right? If you don't reinstate the map now, we're going to be stuck with this map that was drawn by the North Carolina courts for this election cycle. And the Supreme Court denied that emergency petition. They said, we're not going to weigh in just yet. But Alito, Thomas, and Gorsuch, right, back from 2020, Alito, Thomas, and Gorsuch dissented. They thought that the Supreme Court ought to have taken that issue immediately, which suggests to me that they feel like the map drawn by the North Carolina courts is unconstitutional, that should have been left to the states or to the legislature. And Kavanaugh agreed with the idea of not taking the case in February. But he said he wrote a concurrence in that case, and he said, I agree we shouldn't take it now. This isn't fully briefed. This isn't fully developed, but we are going to have to address this independent state legislature thing at some point, right? It's gonna happen. Well, it's happening because now the case it's not an emergency appeal anymore. Now it has gone through the process. It has gone up to the Supreme Court through the regular cert process, and it's been accepted. And we don't know when they're going to hear the case. It's not on the calendar for October or November just yet. So it's probably going to be a while. My guess is they really don't want to hear it before the November election, frankly. But this would be huge, right? If the Supreme Court adopts this independent state legislature theory, it means that any challenges to election procedures, or the vast majority of them, are not going to be reviewable by anybody, unless there's like a federal constitutional challenge, right? Like an equal protection challenge or something like that. But it's going to dramatically limit oversight of the states with respect to elections, like dramatically. Thoughts, questions, or concerns? No. Okay. Is everybody just sad now? Maybe. And the last petition I want to hit today is the next the next battle in the ongoing wedding wars in Colorado. So you may all remember a few years ago a case called Masterpiece Cake Shop. The state of Colorado has a pretty robust anti-discrimination act that forbids discrimination on the basis of sexual orientation for public accommodations. And the Masterpiece Cake Shop case involved a bakery that refused to provide wedding cakes to gay couples who are getting married. They insisted that they would provide other types of cakes to gay patrons. They just wouldn't do wedding cakes because the owner was religiously opposed to same-sex marriage. The Masterpiece Cake Shop case, everybody was watching it very closely. And when the opinion came out, it was actually a bit of, I don't want to say it was a letdown, but it wasn't what anyone expected. The Supreme Court basically said, look, this is kind of a crappy case for us to decide this conflict of rights issue, because in this particular case, the guy who ran the cake shop had pretty good evidence that the Colorado Civil Rights Commission was really, really hostile to him. That they said things during the course of the hearings that could be construed as being very anti-religious. It just muddied the waters a lot, right? It made it look like he was being targeted for being religious. I don't think that's what they were necessarily doing, but that is certainly how it was perceived by many. So the end result was that the case went back, right? The bakery technically won, but not because, but the court didn't say you must allow people to discriminate against gay couples, right? They didn't say that. They just said, in this case, there's evidence that the state was hostile to this person's religious expression. At the time, when the Masterpiece Cake Shop case was sort of working its way through the courts, the attorneys for the cake shop and the Trump administration were both very adamant that this isn't even really a religious exercise case, that really what this is a First Amendment free speech case, and that you're forcing people to endorse weddings with which that they are opposed to, right? That isn't what the Supreme Court said in the Masterpiece Cake Shop case, right? They just never got there at all. Well, now they're going to get there because this company, 303 Creative, is a small web development company, and the owner, Lori Smith, has put together a business plan and started advertising that she is going to move into the wedding website industry. But she does not want to create wedding websites for same-sex couples. And so she has sued, asserting that the Colorado Anti-Discrimination Act is unconstitutional. in her lawsuit, she alleges that it's unconstitutional, both on free speech and on religious freedom grounds. The Supreme Court only accepted one question for review, and it's the free speech question. And this is how the Supreme Court phrased it: whether a public accommodation law to compel an artist to speak or stay silent violates the free speech clause of the First Amendment. And for all my students who are taking gay rights right now, you know that the way a right is framed is often indicative of what's going to happen in the case. And if you had to guess with this one, what would you think?
I mean, it seems pretty obvious that like framing something as just whether or not you have to create art would probably be a violation of the First Amendment.
Yeah. The fact that they're considering this to be artistic expression and they're framing it as compulsory speech, I think they're going to strike down the Colorado Anti-Discrimination Act, at least as it pertains to the wedding industry. So again, that's going to be interesting. That's yeah, it's going to be interesting. I don't want to say I'm eager to see what's going to happen, because obviously no matter what happens, somebody's going to be pretty devastated, but I'm still interested to see what they decide.
Wait, y'all have a gay rights class now? I missed out.
Yeah, teaching LGBTQ rights and the Constitution.
Oh, I would have loved that.
Well, keep an eye out for it. It's 4240.
I graduated already.
Oh, shoot. Oh, that's too bad. So any other thoughts? Has anybody heard of any other cases that are on the horizon that you're interested in? I mean, there are, in fact, there are quite a few interesting cases. There seems to be a weird rush of patent cases coming out, and I have no idea what that's about. The Supreme Court rarely issues decisions in patent cases, but it looks like they're going to take a bunch of them this term. I'm wondering if maybe that's Gorsuch having some effect on the court's docket. I don't know. It's shaping up to be a really interesting year on the court. And like I said, I think it will be particularly interesting with Justice Jackson joining the court. I think we're probably going to see a much more stark liberal conservative divide than we've had even up till now.
I had a question, I guess, going back to Holland.
Mhm.
So I know that Gorsuch has like an interest in like, or I guess what I've read at least is that he has like a lot of interest in like sort of like treaty law, right? And like the Oklahoma case where they like said that there was like a chance that Oklahoma was like still half a reservation.
Yes.
But
What?
like, is there any, like, does he have any like specific like interest in like ICWA, or have they talked about it? Has he like ruled on that before, or like have there been any ICWA cases in a long time?
I don't know. I don't know that there's ever been a Supreme Court case about the Indian Child Welfare Act. I just honestly don't know. Certainly nothing that has made any headlines. And I don't think Gorsuch is specifically focused on that. Like I don't think he has any particular interest in child welfare. He just has a very strong interest in tribal sovereignty. And so while this is technically like a federalism case, it also has this dimension because the tribes are involved and on the side of the federal government. So I suspect that for him, at least, this is very much going to be a tribal sovereignty issue. And that will color the way he sees the relationship between the federal and state governments. Because my guess is that Gorsuch is generally, like most conservative jurists, pretty profoundly in favor of states' rights. But here, where the federal government is purporting to protect tribal rights, he might end up being on the federal government's side. That's
Well, yeah,
just
because
an impression
isn't
that
like a good deal of the like question around tribal sovereignty just like whether or not states have a right, or like whether or not the federal government is sort of like the exclusive, like the like exclusive power that tribes like should make or should be doing business with or dealing with.
So usually tribal sovereignty cases, it's the tribes against the federal government. Like, how much can the federal government regulate the tribes? And here it's how much can the federal government protect the tribes, which is just a slightly different issue. And so again, I'm interested to see where he'll go, whether he will side with the federal government because the tribes support them, or whether he will continue to be in favor of a small federal government and more states' rights and rule the other way, or, you know, decide the other way. I'm just really, yeah, I really don't know what he's going to do.
Yeah, that makes sense.
But my guess is whatever he does, he's going to write an opinion because he really cares about these things. This is like one of his little hobby horse issues. Any other last questions? Well, I know there's another event about voting that's starting in like 3 minutes, and I absolutely don't want to make anybody who is going to that late. But if you have questions, for those of you who don't regularly see me, my email address is wendy.watson@unt.edu. And you're welcome to send me your thoughts on the cases or any questions you have, and I will try to find answers for you. So thanks for joining me tonight.
Thanks, Dr. Watson.
Bye, guys.